Thank you, everybody, for joining us. My name is Jie Huang. I am an immigration attorney at Scott Legal PC. Today, we are going to discuss a very important topic of interest, which is what are the options available to non-immigrant workers in the United States who may lose their job. So just a few things before we get started. Scott Legal is a full-service immigration law firm. We assist individuals pursuing various types of visas, including employment-based, investment-based, and family-based. We have deep experience in E2 visas, E1 visas, L visas, H1B visas, TN visas, and O1 visas, and in green card applications in various categories. We will be continuing this webinar series, and we are doing at least 2 webinars a month on different immigration law topics, so feel free to tune in to any upcoming webinars as well. At the end of this webinar, we will be sending out a few things to all participants. First, we will send you a copy of the PowerPoint that is used in this webinar. We will also be sending you a comprehensive guide covering all the visa options covered in this webinar. We will also send you a link to where you can sign up for any upcoming webinars in the future, and also a link to this webinar as it will be recorded. This webinar will also be available on YouTube, and we encourage you to subscribe to our YouTube channel as we do regularly upload immigration law related videos. Finally, we will be sending you a link where you can set up a consultation with one of our experienced lawyers. So today we are very lucky to have Kelly Legrand-Wiener, managing attorney at the firm with profound experience in all of the visa options that we will be discussing today, who will be presenting about some of the options a non-immigrant worker may have after they have been laid off. Finally, for any questions you may have, please feel free to add them to the chat box or the Q&A box, and we will try and get to all questions. So without further delay, I will turn it over to Kelly.
Thank you so much, GA, for that wonderful introduction. Yes, so today we are going to be talking about, I think, a topic that's on a lot of people's minds, since unfortunately we all know that there have been lots of layoffs, particularly in the technology sector, where there are many workers who are on visas. So, layoffs, this is a difficult time for anyone, but when you also have to consider your visa status, it is particularly stressful. So today we'll be talking about kind of some options that you have, some things you should consider. And if you do need to end up departing the United States, what are the options to come back? So it is important, I think, to just, try to plan ahead. Oftentimes employers will have, some counseling, but you also, may want to reach out to an immigration attorney, to just talk about your options. As a first step, what I always recommend is you want to check your I-94. So if you were in one of the statuses listed on this slide, so E1, E2, E3, H1B, H1B1, L, O, or TN, you may be eligible for a 60-day grace period. This grace period, so let's say that you're laid off, you look at your I-94 and it expires sometime in 2024, and you're on one of these statuses. So in that case, you would have the full 60-day grace period. Now, let's say that you get laid off, today, March 1st, and your I-94 expires March 30th, 2023. So in that case, you would only have a 30-day grace period. You only have until the end of your I-94 if it's less than the 60 days. So always really important to check that I-94 right away, because if you were in a position where your I-94 was close to expiring, unfortunately, that may mean that you don't have, that full 60 days. And the 60-day grace periods, they are discretionary. So, it's not that you have some absolute right to this grace period, but it is something that was provided as part of a new law that was passed in 2017 to help workers in this type of situation, either when they're laid off, perhaps they resign, voluntarily, just any time when the employment ends prior to what you would expect, you have this grace period. And the grace period doesn't permit you to work. So it's not, when you're on that 60-day grace period, you aren't permitted to kind of, start work for a new employer without an authorization. However, what it does give you is time to plan. So filing a change of status, filing a change of employer, all of those things are permitted during the grace period. So it's really meant to give you time either to plan, okay, I'm on an H-1B, I want to change my employer. You can do that within the country on the 60-day grace period. Perhaps instead you change status, or you plan, you make your plans to kind of depart the United States. So, that's kind of another potential option. So it's just meant to give you that extra time, because previously there was no grace period. So if you were laid off, you immediately were essentially out of status, and your only option was really to depart the United States and then try to find, some way to come back in. So these grace periods do give you that benefit. So let's talk a bit about kind of an H-1B. Many people who, were part of these layoffs were on H-1B visas. It's a very common visa in the United States, particularly in the technology space. So the H-1B has some particular benefits available that are important to keep in mind. So if you were laid off and you're on an H-1B and you still have remaining time on your 6 years, so you can get an H-1B and renew for up to 6 years, then you can port to a new employer. So if you find a new employer within that 60-day grace period, you can go ahead and have them file a petition for you. And as long as it's within that timeline, you can start working right away based on the portability regulations. So once the petition is received by USCIS, you can actually start work. If your 6 years are up, but you're eligible for an H-1B extension because you were part of the green card process, either from this employer or a prior employer, then you can also go through that same process of doing a change of employer and having this new employer file for you, so that you can start working again on your H-1B status. In that second case, though, you do need to be prepared to provide the documentation that's required for the extension. So an extension can be granted for 1 year if it's based on, a labor certification or I-140 that was filed 365 days ago and hasn't yet been, denied or revoked. And if you have an I-140 that was approved, but you are not eligible yet to file for a green card because there's a delay in the availability of immigrant visas, then you can get a 3-year extension. So this is very important to just be aware of, what's been filed for you, when was it filed, did your employer withdraw anything? So this is a really key point, I think. If you had an employer that's in the process of laying you off, and they filed an I-140 for you, and this I-140 is approved, you can ask them perhaps not to withdraw the I-140. There is no requirement in the law that the employer withdraw the I-140 right away. And it doesn't have an implication the same way that if you have an H-1B petition, they may want to withdraw that proactively because there's wage implications for what they're going to pay you. But for an I-140, there isn't that concern, and your employer may be willing to hold off on withdrawing it, for at least 180 days after approval. And the benefit you get from that is then you can use that I-140 for future extensions. So this comes up a lot for Indian nationals whose, where the EB2 and EB3 categories are extremely backlogged. So if an I-140 has been filed, you could, and as long as they don't withdraw it, within the 180 days, you can potentially use that for a significant amount of H-1B extensions based on that, that exception for, long delayed, immigrant visa availability. So just something to keep in mind, something to potentially talk to your employer about. Oftentimes they will try to work with you, and they may be willing to do that. As I mentioned, one of the benefits of H-1B is that you are permitted to start working for your new employer as soon as USCIS receives that H-1B petition. And under the portability regulation, that work authorization will continue until a decision is made on the case. So if the case is approved, then based on that approval notice, you can just keep working with no interruption. And if the case is denied, then the work authorization would end once it was denied. However, you would have, it's not that like you violated your status or anything, because the portability regulation gave you that ability to work during the time that the petition was pending. So one other option to talk about with H-1B, we've used the term self-employment, but self-employment is really not permitted in the traditional sense with an H-1B, since there has to be a legitimate employer-employee relationship. But the reason we phrased it this way is what you can potentially do is you could, if you are planning to start your own company, perhaps you even had your own company where you were just a passive owner, and you have a co-founder, perhaps there's a board of directors, or you have the ability to kind of work with people to create one. It may be possible to essentially have a company that you own or have an ownership interest in to sponsor you for an H-1B visa. I'd say there's a lot of caveats here because these are very heavily scrutinized petitions, and there really does have to be a structure in place. So it couldn't be that just you incorporate an LLC, you're a sole owner, you put some money into a bank account and you file an H-1B petition for yourself. That will not work. That is not possible to do. But what might be possible is if you had a co-founder, if you had a board of directors, if there's a detailed employment contract that outlines that you as an employee can be, fired, that there's these board of directors or this co-founder has control over your salary, has control over your work product, has control over your work conditions. All of those things have to be in place and have to be memorialized in proper documentation, to show that, this company that you have an ownership interest in can sponsor you because there is that legitimate employer-employee relationship. So there has to be all those hallmarks of that relationship, and you as the employee, have to be in a position where your work is actually being controlled. Another thing to consider if it's a startup, that you're working on is that the USCIS may ask if there's actually enough specialty occupation work available for you to be able to, work there for 1 year, 2 year, 3 years, however much you're asking for, up to 3 years. So if this is a brand new startup, you would need to have, contracts that show that there's enough specialty occupation work, and that work would actually have to be in your area of specialty occupation. So if you're, you have a degree in, computer engineering, that might not necessarily translate to you being CEO of the company. You would have to consider what is the job you're going to do for the company, and it has to align with your degree as for any H-1B petition. Another thing to consider in this type of scenario is that they could question the company's ability to pay the prevailing wage. So we know for H-1Bs, there's a requirement that you are paid the prevailing wage for the position. You have to meet compliance requirements. So all of the proof of that money being available to the company to actually pay the prevailing wage is something else they could question. So, while this is potentially an option, I think that, if somebody has done nothing on this and is really looking at a 60-day grace period, it would likely be quite a lot to get done, before you're filing. But I think it is a good option to keep in mind because it's something where you may leave the US and try to come back in the future on this arrangement. Or if you were already in a position where you had been working with, a co-founder, or you were a passive owner in a company, this is potentially something to consider. Just one option, although I'd say a much riskier option than just transferring to a new employer. All right, so let's talk about changing your status. So whether you're on an H-1B or another type of work visa and you were laid off, another thing you can do, during your grace period is change your status. So, this allows you not to have to leave the United States, and you can consider changing status to many different, types of statuses. So one would be changing to another work visa. So let's say that you are interested in starting up your own company, you have a substantial amount of capital to invest, you want to run your own company, and you're a national of a treaty country. So the E-2 visa may be a really good option if you've had entrepreneurial aspirations and you want to invest a substantial amount of money into the United States to start up a business that plans to hire US workers, where you plan to be kind of the person developing and directing that company. That can be a great option for you. Unfortunately, the E-2 visa is not available for nationals of India and China. So that can be a really, a stumbling block sometimes, given that you do have to have that requirement of having a treaty country nationality to take advantage of the E-2 visa. But one other thing about the E2 visa, let's say you're a dual national, perhaps you're a national of India and Canada. Canada is a treaty country. So if you enter the US on your Indian passport, you would not be able to change status in the US because the Canadian passport is the one that has the treaty country nationality, but it's a potential option for you to apply for an E2 visa at a consulate. So this is just something to consider if you are a national of a treaty country, and there are many treaty countries, in Europe, in Asia, the Middle East, there's many. So it's worth looking at that list to see, are you on it? If you do have that substantial capital to invest and you do have entrepreneurial aspirations, this could be a good option. Another potential work visa option are the O1A and O1B visas. These are for people with extraordinary ability. O1A has a higher standard, is for, business sciences, athletics. O1B is for art, for the arts. So this is something generally for people who are, have risen to the very top of their field, can show sustained national or international acclaim. So it's if you are kind of at the beginning of your career, perhaps you went to college in the United States and you just got an H-1B visa and you've only been working a couple of years, this is likely not the appropriate category for you. However, if you are someone who has worked in your field for many, many years, decades or longer, you've published many papers, you're well known in your industry, you can show prizes and awards, you can show that you've, been selected to speak at conferences. This is something perhaps to consider, and to do an analysis with an immigration attorney to see if perhaps you might meet this criteria. That being said, the O1A and O1B visas, O1A is a higher standard. O1B is just distinction. So for the arts, it's a bit easier. But if you're in business, you really need to be, someone who's risen to the very top of your field and can demonstrate that through a significant amount of documentation. So, something just to consider. Another option for nationals of Canada and Mexico is the TN visa. If you have a job offer from a U.S. employer and a degree in a relevant field. So there's a list on the U.S. Mexico-Canada agreement. There's a list of occupations that qualify. So for example, accountant, architect, lawyer, many others. If you have that degree, it's something that is a great option. And if you're a Canadian, it's even simpler. You don't need, if you can do a change of status, or you could just go to a port of entry with your proof of your degree and your job offer letter. If you're a Mexican national, you could change status, or you could go to a consulate to get that visa stamp. And I'd say as visas go, the TN is one of the least onerous in terms of documentation that's required. So just something to, to keep in mind. It's not on this list, but if you are an Australian national, you could also, change status to what we call the E3 visa. And the E3 visa really mimics the H-1B in terms of its requirements, but it's not subject to that H-1B cap. There's another limit on it, but it's really never reached. So if you are an Australian national, an E3 can be a really good option for you. So moving away from kind of changing status to a work visa, another thing you could consider is many people are in the US, perhaps they're, married to another non-immigrant visa holder. It's very common sometimes for, both members of a couple to be on H-1B or some other visa. If that's the case, then you could potentially change your status to a dependent status. So let's say, you and your spouse are both on H-1Bs, you're laid off, you don't find a new employer in time, you could change your status to H4 while you are, kind of waiting to figure out your next step. The downside of this is just that dependent applications can take quite a while to be adjudicated, and there's currently not an ability to premium process that application, but it does give you the ability to stay in the US. So it kind of depends on your goals as to, what you choose to do. And then finally, if you're not in a position where you can get a dependent status, if you're not in a position where any of these work visa options, are viable for you, but you do want to stay in the United States, you could consider trying to change status to another status. So for example, let's say that you are, in a position where you just need a little bit more time to sort out, the logistics of a move abroad because you've lived in the US for a long time, you might consider, changing status to a B2 tourist status, just to give you some more time to stay in the US legally while you sort out, whatever your plans are for moving out of the US. Some people choose to go back to school and they may say, okay, you know what, this is a good time to pivot and start my master's degree, or, this is a time to start my PhD. And in that case, you could change your status to F1 status. The issues here are that there is no ability to premium process these applications. So kind of depending on, let's say that you do want to go for your master's or PhD, depending on your background, it may be better to just get an F1 visa at a consulate as opposed to changing status, because that change of status, you could be waiting a long, long time, months, even over a year, whereas you could get it much faster at a consulate. Visitor status, it's very often the case, you can only ask for 6 months, and it's very often the case that you don't have an answer by that time. So once you're at that point, you either need to depart the United States, at the 6-month mark, or you need to file another extension, which again will take a very long time to be approved. So, just something to keep in mind, that if you do go that route, there are potential implications, because if you file for a change of status and you leave before it's adjudicated, it will be considered abandoned. This doesn't mean that you can't get a new visa in the future, but it does mean that that denial will come through and that you'll kind of be considered to have been out of status for that period of time that you stayed beyond your I-94. The out of status is different than unlawful presence, so it wouldn't bar you from reentry, but it's something to consider, could have potential implications and will have to be discussed on any future, DS-160s. Let's talk a little bit about, filing for an adjustment of status, during this time. So a change of status would be a change to a new non-immigrant visa status. An adjustment of status would be filing for a green card. So that's something to consider. Is it the right time to pursue a green card? Perhaps you're in a relationship with a U.S. citizen or a green card holder, and you've been discussing marriage and you decide this is the right time. It's possible to file for that adjustment of status, during your grace period, or if you're marrying a U.S. citizen, even beyond. Similarly, it's possible to consider some employment-based petitions where you have the ability to self-petition. So the EB-1A Extraordinary Ability Green Card, does give you that ability to self-petition. So if you are someone, who has that sustained national or international acclaim in your field, has risen to the very top of your field, there's several criteria that you would need to meet, to show that you've risen to the very top of your field, that you're a thought leader in your field. That's potentially something to explore. Again, that's for people who really have, extensive credentials, extensive accomplishments. When you Google their name, it comes up with tons of publications or, with tons of information about them. And depending on your field, that may not happen. But the purpose is that, there should be all that documentation to show you have that sustained national or international acclaim. Another potential, self-petition is the EB-2 National Interest Waiver. So if you have either an advanced degree or, the U.S. Master's or higher, or a bachelor's degree plus 5 years of post-baccalaureate progressive experience, or you can show you have exceptional ability. That's kind of the threshold requirement for EB-2. And then to show that you're going to, it's merited to waive the requirement of a job offer and a labor certification, you would show that you have a proposed endeavor in mind that has a, substantial merit and national importance, that you yourself are well positioned to advance that proposed endeavor, and that on balance, it's beneficial to the United States to waive the requirements of the labor certification and job offer. So if you, let's say, you have a business idea you've been working on, you have some patents, this is going to revolutionize a particular area of an important industry. These are things to keep in mind, perhaps even in your H-1B work, you were working for a very, well-known company, and now you want to take, what you've learned and turn it into your own enterprise as an entrepreneur, or, work with various companies as a consultant. It's something to keep in mind because you do, potentially have that ability to do a national interest waiver. The EB-5, so you can do either a direct or a regional center investment. You're investing either 800,000 or $1,050,000. And that can also get you to a green card if if you're able to invest that substantial capital into a new commercial enterprise that ultimately creates 10 full-time jobs. So we have specific webinars that go over each of these green card options in significantly more detail. So if you were interested in these options, I would strongly encourage you to attend those webinars because there is a lot more information out there about each of them and whether you might qualify. And we also provide, guides for each of those, green card options. So another thing just to mention in terms of kind of what benefits are conferred when filing for an adjustment of status, the filing of an I-130 or I-140 on its own does not provide any status to you in the United States. What has to happen is you have to also be able to file the I-485 green card application. So it may be that, for example, for EB-2, if you're an Indian national, it's very backlogged. So you would not have that ability to do what we call a concurrent filing, where the I-140 and the I-485 are actually filed together. So as of right now, the national interest waiver, the EB-2 category, is backlogged generally. So it's something to keep in mind just in terms of, can you file the I-485? If you cannot, then it doesn't give you the ability to stay beyond the 60-day grace period. If you can file it, then yes, you can stay and should stay if you file it. Otherwise, you would abandon it. And when you file it, you can also file for work and travel authorization. Those applications are taking several months to be approved. However, filing the I-485 would give you that ability to stay in the United States while you're waiting, to hear back on your petition. All right, so let's talk a little bit about what happens if, you're not able to kind of change status, you're not able to find a new employer. Very important that you want to avoid violating your status. If you're getting to the end of your 60-day grace period, you need to make a decision as to whether you're going to try to change your status or whether you're going to depart the United States. And you should depart, before the grace period expires. In terms of, status violations and unlawful presence, you do not want to be accruing, more than 180 days of unlawful presence. That can lead to a 3-year bar. Over 365 days can lead to a 10-year bar. So you want to be very careful about overstaying, the I-94. If, for example, let's say that you get to the end of the 60-day grace period, some emergencies have happened, you overstay a couple extra days, but your I-94 is still valid. You would be considered to have spent some time out of status. It's something you would have to describe on your DS-160, since there are questions about whether you've ever, overstayed the period of time, that was allocated to you. But it doesn't prevent you necessarily from getting a visa in the future. And even if you did accrue a few days of unlawful presence, that also doesn't prevent you from getting a visa in the future. It just is something that has to be described and explained when you apply for visas in the future. Something to keep in mind, for H-1B, E-3, and O-1 workers, the employer will, need to pay reasonable transportation to the, country of last residence. So that may be something you want to talk about with your employer. And in terms of re-entering the US, if you are in a situation where you were speaking with multiple employers, but you just couldn't kind of get something put together or filed within the grace period, that's okay. You can continue talking with those employers when you're outside the United States and, apply for the visa at a consulate to re-enter the US. I think during the pandemic, it was very, very difficult because it was very difficult to get any visa appointments at the consulate. We're definitely in a much better position now than we were then. Consulates, although they've been quite uneven in the return to visa processing, for many consulates, they are in good shape. They are processing visas much more normally. And so that means that applicants have a bit more flexibility, to perhaps go to other consulates, whereas previously consulates were, very, very reluctant to process third country nationals because, the backlog was so great, even for nationals of their own country. We're now seeing that many consulates are more willing to process third country nationals. And so there are just more options for visa issuance if you are in a situation, where you had to leave the United States. Other things to keep in mind are, many consulates now will offer interview waivers if you're trying to renew a visa where you've already been granted that visa. So let's say you were on an H-1B and now you're trying to renew your H-1B. There may be an ability to, have your interview waived. So these are, just because you can't find a new job within the 60-day grace period, it doesn't mean you won't be able to re-enter the US with a new work visa, but you do want to avoid staying beyond the time, that you were allotted. Otherwise, you will have to, report that, and it could potentially complicate future visa applications. All right. So I think we are at the end of the presentation, and I don't see any questions. So I think we can close here. Thank you so much, everyone. And thank you, GA, for joining me.
Thank you, Kelly. That was great.